All right, we're back. Welcome back. I've been talking about patents and trade secrets, two different ways of, if you have an idea, of protecting the idea. And what's really interesting is that with trade secret law, there's no formal registration requirement. All you have to do is have a good idea that's commercially valuable and take steps to keep it secret. Um, Totally different from the patent registration system under federal law for protecting inventions, right? But there's two different ways of going about. Now, one of the advantages of trade secret law, and you notice Google has done both. Now, almost everything Google does is really protected as a trade secret, but sometimes they'll get a patent. When they began, they had that original patent that I've shown you in Module 4. Patents expire, right? Patents expire if it's a so-called utility patent, or what you normally think of when you think of a patent, a new, novel, non-obvious invention. It's 20 years. It's 20 years. Whereas with trade secrets, trade secret protection can go on indefinitely as long as your idea continues to be commercially valuable, and as long as you continue to take steps to keep it a secret. Now, this is going to take me as a digression. I do want to talk about the founding of Facebook, even though we narrowly voted for Tiger King here. We'll talk about Facebook because really what Facebook is ultimately about, the dispute between the Winklevoss twins and their company called ConnectU, originally Harvard Connection, and Mark Zuckerberg and Facebook. It really comes down to what lawyers call misappropriation of trade secrets. In fact, just for your reference, if you want to take a look, I've included the original legal complaint that the Winklevoss twins brought, or that ConnectU, on behalf of the twins, who are the owners, along with Divya Narendra of ConnectU, the original lawsuit that they brought against Mark Zuckerberg. And what's really interesting about that lawsuit, you'll see there's a whole bunch of allegations, whole bunch of different legal theories, unjust enrichment, breach of contract, but really even fraud. But the main one is going to be, and I think the first one is misappropriation of trade secrets. And what misappropriation is a fancy word for you stole my idea, which is really what the movie The Social Network is all about. Now, here's what I want to talk about in this video. Reverse engineering of a trade secret is perfectly legal. Like if you can figure out, how Google search works now that it's protected mostly as a trade secret, or if you can figure out, how to make your own recipe for a chocolate chip cookie that's as good as Famous Amos's, or your own Tabasco or your own Coca-Cola formula, right? If you can figure out on your own how to do that, another good example of a trade secret is WD-40 formula, right? If you can figure that out just using your own ingenuity, buying the product, studying it, tinkering it, that's perfect, tinkering with it until you come up with the very same formula. You can go ahead and do that. And that's why, by the way, after this, I'm going to talk about trademark law, because what these companies do, whether it's Tabasco Company or WD-40 or Coca-Cola or even Google, they also have trademarks, so that even if somebody else has a search engine that's just as good as Google, only Google can have the Google trademark. Or even if somebody else comes with a good recipe for hot sauce, only Tabasco owns the Tabasco trademark, the Tabasco brand. So you can see how these things work in conjunction, right? This is why the law of ideas is so important. So reverse engineering is fine, but outright theft is not. And here's the thing, right? The Winklevoss twins, they do sue Mark Zuckerberg for basically, him stealing their idea. What's interesting is the case was settled out of court, so we don't know how it would play out. I just want to share my own views here. And my own views are that go back to the original requirements in order to protect an idea as a trade secret. The idea has to be commercially valuable. And guess what, right? When the Winklevoss twins had their idea for a Harvard social network, originally to be called the Harvard Connection, think about it. That is a commercially valuable idea. That's something that people probably wanted to join and would have some commercial value. The idea was good enough that even Zuckerberg was willing to give of his time to work on their project, right? That's telling me it's a commercially valuable idea. But go to the second requirement of trade secret law. Did the Winklevoss twins, with their partner Divya Narendra, did they take steps to keep their idea a secret? And here they're in a little bit their case. I can see why they settled out of court, right? Because the moment they shared their idea with Mr. Zuckerberg, right, without any evidence that Zuckerberg signed a non-disclosure agreement or confidentiality clause, as part of an employment or work for hire contract, right? It's going to be very hard. How do you prove to a judge that you took reasonable steps to keep your idea a secret? Now, in fairness, right, all of these people are college students and they're friends. They're hanging out, right? This is informal. So maybe we wouldn't, maybe a court might be more lenient when it comes to college students, right? In terms of, okay, maybe if I'm the Winklevoss twins, I'm going to argue that, look, they're college students, Your Honor, give them a break. Plus, in their defense, they only shared their idea, their source code for their, their idea for their Harvard social network only after Zuckerberg promised to help them out with their website. So you could argue that, although I don't have a formal non-disclosure agreement or something like that, and sometimes in business when you're getting started, nobody wants to sign these things, right? But really the best practice is to, ideally, in an ideal world, is before you share your idea with someone or a potential investor, potential partner, somebody outside of your family, and maybe even within the family, it is a good idea to have some kind of proof that you're trying to keep your idea secret. And generally courts do like to see a non-disclosure agreement, or if you have another type of an agreement with the other party, a confidentiality clause within the contract. So that's just sort of, some good housekeeping rules for, this is why you need a lawyer, basically, right? To help you navigate the common law in your state and what judges in your state will require. What steps do they consider reasonable steps to say that you're keeping your idea, trying to keep your idea, your commercially valuable idea, a secret? The Winklevoss, that's a really close case. Now, I can also see why Zuckerberg settled, right? Both parties settled. They wanted to get this case out of, rather than go to a jury. Now, I'll talk more about that litigation dynamic. When do you settle? When do you go to trial in Module 5? Because it turns out, actually, a lot of business disputes, actually, most business cases do end up settling out of court. It's actually the exception, and it's a very extraordinary exception for a business case to go to a judge for bench trial or to go to a jury for a jury trial. But we'll explain why in Module 5. Here in Module 4, I just want to focus on the main areas of intellectual property rights or the law of ideas. All right, we've seen trade secrets and we've seen patents, two different ways of protecting your actual ideas. In the next set of videos, I now want to talk about what marketers often call is, branding your product, branding your idea, trademark law, as lawyers would call it. And then I also want to talk about copyright law, which is another way of protecting not so much your idea, but the way you express your ideas. So trademarks and copyrights, hugely important in business. So let's take a break here because we've done a lot. Catch our breath, get another glass of water, and then we'll jump into trademark law.